Uh, Hello, everyone. My name is Mike Gulo, and I'm an attorney in Streator, Illinois. And first of all, I'd like to thank Erica and Carrie and the Epilepsy Network, Epilepsy Advocacy Network, for inviting me to join you tonight. And as I indicated, I'm an attorney in Streator, Illinois. Streator is about 100 miles southwest of Chicago. I tell people we're out in the middle of the cornfields. Streator's a small town with probably about 12 or 13,000 in it. And I think probably just as importantly for this meeting is that I am also the parent of a child with a disability who has epilepsy. My son Jonathan is now 39 years of age, and he's had a vagal nerve stimulator put in. He's had a brain surgery, and I don't know how many different anticonvulsants he's taken, but even with all that, he still has surgery. And because of his, situation, that's when I got involved in doing estate planning for parents, of children with disabilities. And it can be any disability. It doesn't necessarily have to be epilepsy, but obviously, some of my clients do have children with epilepsy. So when I work with parents of children with disabilities, there's really two areas that we're working on and trying to protect, okay? One would be protecting the benefits that child receives, because I'm sure, as most of you know, the benefits that a lot of people with disabilities receive are things like SSI, which is supplemental security income. They may also be getting Medicaid, to pay their medical bills. Sometimes in Illinois, we have what we call DOORS assistance, is Department of Rehabilitative Services, and they provide, services for around the home, kind of day services type things. Also, we'd be talking about food stamps. So we want to be able to make sure that we protect those benefits for the child with a disability, okay? And the other thing that I'm usually working on is, to make sure that the child is protected. And we usually do that through what we call a guardianship proceeding, though there are a couple of, there are some alternatives to a guardianship, and I'll talk to you about that. Also, in some states, guardianships are called conservatorships. In Illinois, we call them guardianships, so I'll probably use that name. But in other states, I know they call them conservatorships, where their parents are trying to go into court and become the conservator of their parent. I am also a member of the Special Needs Alliance, and the Special Needs Alliance, and write that name down, Special Needs Alliance. We're a national group of attorneys, and the attorneys in that group sort of specialize in helping parents with children with disabilities. So you can go to their website, and a lot of the information that I'm going to be giving you will be on their website. They have an attorney, I think, in every state in the United States. We recently got an attorney in Iowa. I think that was the last place we weren't in. But the Special Needs Alliance can be very helpful to you as far as finding an attorney and some of the things you need to know as a parent of a child with disability. So like I say, when we're talking about special needs trust, so what a special needs trust is it's a trust that can hold money for the benefit of a child with a disability, but the assets in that trust are not held against that disabled beneficiary in determining their eligibility for SSI, Medicaid, benefits that might have asset and income limitations, okay? And there are a couple of different types of special needs trust. Usually when I'm working with parents, we're doing what we call third-party special needs trust. And third-party special needs trust mean that the money going into that trust comes from a third party. Typically, it's going to come from the parents, as far as their estate plan is concerned. Mom and dad are going to say, well, if dad dies, everything's mom. If mom dies, everything's dad. But then upon the death of the last of them, there'd be money going into this special needs trust. And like I say, the money in that special needs trust would be there for the disabled beneficiaries' extra and supplemental benefits, okay? Things like clothing needs, things around the room, medical expenses that might not be paid, but there's a whole laundry list. I have sheets and sheets, of things that the money in a special needs trust can be used. And again, the money that's in that special needs trust, because it's not the disabled beneficiary's money, is generally not held against that individual in the term of eligibility. There's times also where we use what are called first-party special needs trusts. So I get involved with situations where, let's say, a person with a disability accidentally inherits some money, from a well-meaning grandparent or an aunt or an uncle or somebody else, okay? So again, the person with a disability who's getting benefits that have asset and income limitation unexpectedly receives money, okay? And what we have to do then is to preserve the benefits for the person with a disability. We have to put that, and they call this a first-party special needs trust. First party meaning it's the money of the disabled beneficiary. But the big difference between the third-party special needs trust and the first-party special needs trust is with the third-party special needs trust, after the disabled beneficiary passes away, that money can go to other family members, other siblings, that type of thing. But when we're using a first-party special needs trust, because basically the state and federal government are allowing us to put that money into a first-party special needs trust to protect benefits, but then the kicker on that is when the disabled beneficiary dies, they have to pay back any Medicaid agency where they may have gotten benefits through their lifetime, okay? Another area where I practice a lot is, like I say, in the area of guardianships or conservatorships. Here in Illinois, we do call them guardianships. And the purpose of a guardianship is so someone can take control of the disabled beneficiary's, financial finances, so they can take care of their money. And then also the guardian can take care of their person. So with the estate guardianship, guardian of the estate, again, somebody's going to be appointed to take care of the financial affairs for the person with a disability. And as far as the personal affairs are concerned, that'd be like things, making sure they're getting their education, making sure they're getting medical treatment, making sure that their living arrangements are proper. So that's like I say, what the guardian of the person does. Another way to handle that sometimes too is sometimes, we have a very high functioning child with a disability. So we may do what we call powers of attorney. There's a power of attorney for property or for assets, and there's also a power of attorney for healthcare. So a lot of times with a high functioning beneficiary, okay, we will just have them, sign and authorize a parent to be their power of attorney for property. In other words, help them with their financial affairs, and also the power of attorney for healthcare, which allow the parents to participate in healthcare decisions so they can talk to the doctors in the hospitals and find out what's going on. Another area where there's been some movement in the last 5 or 6 or 7 years is what they call supportive decision making. So it's not a court ordered system like with a guardianship where you're going through the court system. It's in a sense sort of like a little bit the powers of attorney for property and powers of attorney for healthcare. But the supportive decision-making agreement is an agreement between the disabled person and maybe a parent or some other family member, or it could be someone else altogether. But basically what that allows the person to do is to help the person with a disability, make decisions. So again, it's very important for you as a parent of a child with disabilities is to get your estate plan in place, because I've been involved in situations where the parents didn't get anything in place, and we were, struggling to get things done after the parent dies, once that person with a disability has already inherited something. There's another thing that we also use, I guess I'll say another tool that we also use in estate planning for parents of children with disabilities, and it's called an ABLE account. It stands for Achieving Better Life Experience, ABLE. And most states, in most states, you'll have access to an ABLE account. Here in Illinois, we have an ABLE account. We actually have a statute on it too, and that's handled by our Illinois Treasurer. And so we set those up regularly, and what we have to do is we have to make the application online at the Illinois Treasurer's office. We have to have them approve it, and then they, the family can put up to $18,000 a year into that ABLE account, and the money in that ABLE account can be used for what they call the qualified disability expenses of the person with a disability. And qualified disability expenses, you can actually use the money in that ABLE account to pay for things like rent and food and things like that, which would normally negatively affect a disabled person's right to receive SSI or Medicaid. So an ABLE account has become a very useful tool for special needs planners. So again, I'm going to encourage you today, to if you don't have an estate plan in place, to call an attorney, find an attorney who can do a special needs trust or do this planning for you. Okay. And I'll be willing to answer questions. And I know at the end of this, we'll have questions, and I'll be happy to help you with any questions you may have. So that's my presentation. And again, I want to thank the Epilepsy Accuracy Network and Carrie and Erica for being able to present to you today. Thank you.